Hi there all, Jacob Austin, and welcome to episode 155 of the Subcontractors Blueprint, the show where subcontractors learn how to ensure profitability, improve cash flow, and grow their business. Today's episode, we're continuing our disputes mini-series, and we're moving on from adjudication to cover various alternatives, including mediation, expert determination, arbitration, and litigation. When each one beats adjudication, and how to pick the right tool for the job instead of just reaching for the one that you know. So, let's dig in. If you've listened to the episodes in this mini-series, then you now know adjudication better than some main contractors do. Which raises an obvious question. If adjudication is fast, it's cheap-ish, and it gets you paid, why would you ever use anything else? And the answer is, sometimes you'd be mad not to, because adjudication has its blind spots. And today is about the tools that cover them. Right back at the start of this series, I showed you the doors. A quick look at all of your options when the money's stuck. Since then, we've spent weeks going deep on just one of them, adjudication. And now you understand it potentially better than the people sitting across the table from you. So today we're going back to those other doors with completely different eyes, because you now know exactly what adjudication does, so you can also see exactly what it doesn't do. And that's today's whole game. Every one of these other tools does exist to cover something adjudication can't. So the thing to hold on to right through this episode is, for a straightforward payment dispute where you need cash and you need it fast, adjudication is almost always your answer. Full stop. But with that said, not every dispute is that. Some are messy. Some need a final answer, not a temporary one. Some need a remedy that adjudication on its own can't give you. And reaching for adjudication out of habit, when the job really needs a different tool, can cost you as dearly as reaching for court out of anger. So let's learn to make that choice. The first tool is mediation. And mediation covers the thing that adjudication is worst at: relationships and mess. Adjudication produces a winner and a loser. It decides one dispute on the law, and it can be brutal, which is exactly wrong for some situations. If you're mid-contract with a client that you really want to keep working for, and you've got a tangle of disputed variations, some defects flying both ways, and a relationship worth more than any single line item, then a brutal win or lose ruling on one slice of it is the last thing you really want. Mediation is the opposite of that brutal process. You bring in a neutral, down-to-earth mediator, and they don't decide anything. They're a facilitator. They help the two of you find a deal that both of you can live with. And because it's a negotiation, not a ruling, you can settle everything at once. The whole account, all the variations, the defects, the lot. It's not just a vehicle for one single dispute, but clearing up the whole relationship in one day. It's confidential, it's quick to arrange, and you split the mediator's cost so that it's cheap next to the courtroom end of things. The catch, as I said back in episode 1, is that nobody can force a settlement out of you. But here's something that's changed recently, and it's worth knowing. The courts used to say that they couldn't make you mediate at all, and that position has shifted. The courts can now order parties to at least engage in mediation before passing to a full-on trial. And refusing to even try can count against you when it comes to costs. So mediation is no longer something that you can just wave away as it's something that's beneath you. It's now a valid and expected part of resolving a dispute. Second, and this one is one that hardly anyone talks about, expert determination. Picture a narrow technical fight, not a sprawling account, but one difficult question. What is this disputed valuation actually worth? Is this workmanship up to standard, or isn't it? A single expert question where what you want is a knowledgeable person to look at it and give you a definitive answer. That's expert determination. You appoint an expert, a real specialist in an exact thing, and then you give them a question so that they can decide it. Here's what makes it different from other things on this list. It's final, properly final, unlike an adjudicator's decision, which can only be temporary and reopened later. An expert determination is the end of the road, and you're bound by that outcome. That gives it great strength and great danger in the very same breath. The strength of it is the certainty. It's over quickly, quietly, relatively cheaply, decided by somebody who genuinely understands the technical point. The danger is this: because it's so final, the grounds to challenge it are almost non-existent. You can't appeal it just because the expert got it wrong. Even a genuine mistake on the facts or the law will generally still bind you. The only real way that you can unpick it is if the expert answered the wrong question, went outside what you actually asked them to do, or there is some fraud. So if you pick a poor expert or you frame the question badly, you can be stuck with an answer you hate for good. Which means two things matter enormously here. First, choosing the right expert and defining the question with real care. Get those right and it can be a beautiful tool. But get them wrong and there's no way back. So when do you actually reach for it instead of adjudication? When the fight is narrow and technical and you want it settled for good, or just for now? Picture you and the main contractor £10,000 apart on the valuation of one awkward element, and you both just want a straight, expert answer that you can bank and get on with. Adjudication gives you a temporary answer that can be reopened later. Expert determination gives you a final one. For that kind of narrow, single-issue dispute where certainty matters more than speed, it can genuinely be the better tool. Just be clear on what you're trading. You're swapping the right to argue it again for the certainty of a line drawn under it. So you need to go into that with your eyes open. Third is arbitration. Arbitration is a private court, a binding final decision from an arbitrator behind closed doors instead of a public courtroom. Where does it beat adjudication? When you need the final word, not a temporary one, and you want it kept private. And when you want it decided by someone with real industry expertise rather than just a generalist judge. For a big, complex, confidential dispute, that's a genuine draw. But two big warnings for a firm of your size. First, arbitration is only on the table if your contract provides for it. It's not automatic, like the right to adjudicate. Under JCT, for instance, you generally get the courts unless arbitration was specifically chosen in the contract particulars. So you need to check yours. Second, and this is the thing that really matters, is that arbitration isn't cheap. You're paying for the arbitrator, the venue, you're paying your own lawyers, and it can run as an expensive an activity as a full-blown court case, sometimes more, and lasting many months. So for the day-to-day disputes of an SME subcontractor, arbitration is rarely your friend. It's one for big, final, private fights. And it's usually there because the contracts put it there, not because you chose it. Now fourth, litigation. Court. For construction, the serious money goes to the technology and construction court, the same court that enforces your adjudication decisions. Litigation is the real heavyweight. It's final, it's binded, it's public, and it can be appealed. There are real situations where it's the only tool that fits. When you need a remedy that an adjudicator simply can't give you. When the dispute pulls in several parties at once because adjudication only really works between two. And a proper multi-party mess sometimes has to go to court to be sorted. Or when it isn't a construction contract at all, so there's no adjudication right in the first place. But you probably know the sting by now. Court is the slowest and the most expensive route there is. We're talking a year or more, and court costs follow the event. So you lose, you're likely to be paying a big slice of the opposition's legal bill on top of your own. That makes litigation the last resort for most subcontractors, not the first. And it means litigating anger, storming off to court because you're furious rather than because it's the genuinely right tool, one of the most expensive mistakes in the entire industry. Now, before we get to the mistakes, there's one thing sitting in your subcontract that controls where this whole episode goes. And a lot of people won't read it until it's far too late, and that is the dispute resolution clause. It does two jobs. Firstly, it names your route to settling a dispute, whether the last word on this contract is arbitration or it's the courts. You don't get to choose that in the heat of a row. It's settled on the day you signed your subcontract, and you want to know it long before you ever need it. Second, and this one can catch you out, is it can set a clear order that you're supposed to use these resolution methods in. What's called a tiered or an escalation clause. It might say you have to sit down and negotiate first. It might specify key principles that you're supposed to negotiate between, and by principles I mean the two MDs potentially sat in the same room. Then, if that goes nowhere, you have to go to a mediation. And then, only if that fails, are you allowed to go to a tribunal, either the arbitration or the court. That's an example, and it's a staircase in that situation that you would have to climb in order. And the stinger is, if your contract makes those steps mandatory and you skip one, if you go storming off to court without doing the mediation first, and your subcontractor tells you to do that, the other side can stop your claim in its tracks. The dispute gets stayed until you go back and you do the step that you missed. That can mean months lost, costs wasted, all because you didn't read one clause. So you need to read that. You need to know your final route. Know whether there's a long staircase standing in front of it. But there's one saving grace, and you'll already know this from earlier in the series. None of that touches adjudication. Your right to adjudicate is statutory. It sits outside that escalation clause, and it can't be contracted away from you. It's there at any time, whatever hoops the contract puts in front of other routes. So even if your contract builds up this long staircase towards an arbitration, the fast door to a decision is still sitting there, right next to you, whenever you need to use it in the form of adjudication. So where does choosing the right method go wrong? The first would be reaching for court in anger. Picture you being furious, so you want the biggest hammer in the box. But the biggest hammer is the slowest and it's the most expensive, and it can leave you paying both sides' costs. Your anger is the worst possible reason to pick a particular method of resolution. The second way to go wrong would be not reading your own contract. Your subcontract has a dispute resolution clause, and it matters. It tells you whether your final route is arbitration or the court, and it might set out those escalation steps that you have to follow first. Those that we've just mentioned: negotiate, then mediate, then ultimately tribunal. Ignore those steps and you can trip yourself up, so read the clause before you're ever in a dispute. The third mistake would be treating mediation as a weakness. It isn't. Choosing to negotiate the way to settlement in a long day of commercial discussions and maintain a relationship with a client that you are hoping to keep isn't soft. It's very much and very often the sharpest commercial move on the table. The fourth way this can go wrong is not understanding how final an expert determination really is. People can agree to doing it without registering that there's basically no way back if it goes against them. So you really have to respect the finality of that agreement before you ever sign up to it. The fifth thing is one that you should never forget. Adjudication is sitting there alongside all of these other methods. It's your statutory right, and it doesn't disappear just because your contract also mentions arbitration or the court. The Construction Act says you can adjudicate at any time. For most of your disputes, it's still the first tool you reach for. These alternatives are for the times when it genuinely isn't the right fit. Let's think about a scenario, because this whole episode is about making the right choice. Picture a fit-out subby, and he's halfway through a good contract for a client that they've worked with for years and they want to keep working for. But this one's got messy. There's a stack of disputed variations, over 100 grand's worth. The main contractor is also alleging various defects, and the subby reckons that half of the defects claims are just nonsense, and the variations are badly undervalued. It's a tangled web, and there's fault on both sides. And also, there's still a lot of work to come on the job. The angry instinct here might be to adjudicate, fire in a notice on the variations, grab the cash, and they probably could. But walk through the scenario. Adjudication would decide one slice of this, the variations, on the law. It wouldn't touch the defects at the same time. It would turn a working relationship into a war mid-job with months' worth of work still left to run. And then they'd still have the defects fight hanging over them afterwards, so they might even have to do a second adjudication for that. Instead, they think about it and they pick the right tool. They propose mediation. One neutral, single day with everything on the table at once. The variations, the defects, all of it. And in that room, with a mediator moving between them, they carve out a deal. The subby gives a little on two of the weaker variations, and the contractor decides to drop some of the flimsier defects claims. Eventually they land on a number that this is all worth, and crucially, they shake hands and the job carries on. That relationship survives, and the work keeps coming. All at the back of the mind is the safety net. If the contractors refuse to engage at all, the subcontractor still has adjudication in their back pocket the entire time. That's the whole point. Mediation first, because the relationship and the mess that's been made on this job make it the right tool, with the hard statutory weapon still there if the softer approach has failed. That's choosing, instead of just swinging for the other side. So what do you need to know? You need to read your dispute resolution clause before you need to know it. Know whether your final resolution method is arbitration or the court, and know whether there are escalation steps that you have to take first. Match the tool to the goal, not to your mood. Need cash fast on a payment dispute? Go to adjudication. Need to save a relationship that matters and untangle a mess? That's mediation. Need a final definitive answer on a technical question? That's expert determination. And finally, if you need a final definitive answer on something that adjudication can't resolve, or you might have several parties in the mix, that goes to the courts or arbitration if the contract says so. Respect the cost risk at the courtroom end. Arbitration and litigation both carry real costs, and in court the loser generally pays the winner. So don't walk into that situation half-cocked because you're angry. Understand finality before you accept it. Expert determination and arbitration both give you an answer that you're then stuck with forever. That can be a strength when you want certainty, and a trap if you go in carelessly. And never forget that adjudication is in your back pocket. So that's your full toolkit. Adjudication, the 4 alternatives, and how to choose between them. Next week we'll be finishing off the series with the most important episode of the lot, and the one that nobody wants to give you. When to not fight at all. Because knowing how to win a dispute is only half of it. The real skill is knowing which battles to walk away from. We'll talk costs, relationships, the state of your records, and the big one, insolvency. Why you can win everything and still collect nothing when the other side goes under. That's the episode that draws everything together and ties the whole series together. Don't miss it. My mission with this podcast is to help the million SME contractors working out there in our industry. If you've taken some value away from today's show, then I really need your help to share the show and pass that value on to somebody else who'd benefit from hearing it, so that I can help as many people as possible. And thanks for tuning in. If you like what you've heard and you want to learn more, then please do find us at www.subcontractorsblueprint.uk. And we're also on all your favourite socials, again at Subcontractors Blueprint. And remember, miss the contract detail and the commercial risk falls on you. Thanks all. I've been Jacob Austin, and you've been awesome.